your case is actually a contested matter where there's two different versions of the story. There was an accident at the Centerville High School parking lot. And that was on September 18th of 2025. Miss Brandeis contends that her car was hit by Miss Carly Danielle Swartz Friesen, and that she was leaving the scene and they stopped, got her information. Defendant represented that she was covered by insurance, and it turns out she was not. So there are arguments that this is not covered by the no-fault statute because A, Ms. Friesen didn't have any insurance, and B, it happened in the parking lot of a school. And so Ms. Brandeis has supported or submitted evidence to show the amount of damages she received as a result of this accident. That doesn't take much. She has a quote from Chuck's Body Shop of Three Rivers. And that is the amount of $2,211.51. Parts, labor, taxes. That's the quote you have to repair your car. Is that correct?
Correct.
Have you actually had the work done?
I did. It was done, I believe, on October 22nd through the 24th.
So your automobile has been repaired and you're out this amount of money.
Correct. I paid out of pocket.
All right. Ms. Swartz Friesen, what's your response?
There's this whole thing was a bit of a mess. The parking at the school we weren't even parked in parking spaces. So I don't know if that was made clear on her end or even mine to be whatever. But so yeah, I was parked like everybody else, like a half circle, and she was parked more or less outstandingly, kind of behind
What
me.
event were you there for?
My daughter's cheer practice, and so we all kind of park on the grass in a half circle, kind of like a slant. At a slant, we're in the grass, and she was parked completely totally wrong from me at all. And so yeah, when I went to back up, I backed right into her car. I didn't see it. Genuine accident. I also I had no idea that my insurance was not on my car. It was coming out of child support, so I don't use that account. I don't look at that account.
At this point, the facts are no longer in dispute. The defendant openly admits she backed into the other vehicle and later discovered her insurance had lapsed. Now the case isn't about who caused the crash, it's about who should pay for the damage. The judge is listening carefully to determine whether this was simply an unfortunate mistake or a legal responsibility that can't be avoided.
It's not even something that I notice. So I had no idea that it was stopped. So when she had made the statement that I had given her false information, sure, that may be true. But I didn't know that. That was not my fault.
Tell me that. You didn't know that your insurance had lapsed?
No, I had no idea. I hadn't gotten any information about that.
All right. Well, your insurance is paid automatically out of your child support?
Yes, it's auto pay.
So the child support goes into an account and then you auto pay out of that account to your insurance company?
Yeah.
All right. And at some point that didn't happen, so your insurance lapsed.
Yes, because child support is kind of up and down and backwards and all around.
You don't always get it.
Yeah. And like I do, but it's like smaller amounts or it's less than what it normally is sometimes. So that's the problem there. And I have also have no problem paying Kristen or whatever her name may be back. I have no problem doing that. But the issue that I have is she was kind of yelling at my wife at this game in front of children and mothers and grandparents alike. And that kind of set me off. It set obviously my wife off. That's not very professional. And then I didn't have Brandy's number. I didn't have her information. So when I reached her, she did not give me any information as to what her car was, how much her car was to fix. She let my wife know that. And didn't give any paperwork, gave no proof, gave nothing of that, just kind of demanded out of her mouth that we owe her $2,000. Okay, well, I'm gonna want a little bit of proof. My car also has damage. I mean, my tail light, my bumper, I have her black paint smeared on my white car. So, you know, there's damages on both ends. I understand hers is probably a little bit more severe. It was a whole door, whatever else it might have been. But yeah, I just so when I reached Brandy's, when I did finally get a hold of her, I called her workplace because I had no other way to get a hold of her. And the first thing she told me was that this was extremely unprofessional and that I had no business, I guess, technically calling her like this. But then she seemed to calm down a little bit. I calmed down a little bit. We actually kind of seemed to talk. And it seemed like we were on a I thought what I thought was an understanding, and I messaged her my number to show her that I wasn't lying, I wasn't trying to hide anything, that this was genuinely me. She responds with thank you, and then I hear nothing, and then I get certified mail in the mail, and I'm like, okay, this is a little bit of a shocker. I didn't mind paying her. I just wanted a paper. I just wanted something stating that this was actually the cost of it. That's all I wanted.
Well,
And
that's not, well, I'm gonna give you that.
so that's really where I'm at. Like I said, I'm not trying to be unfair or unreasonable, but yeah, it was a two-way street. I mean, there was words that were being exchanged that didn't need to be. There was things that happened that shouldn't have happened on both ends. And yeah,
My son was in an accident once. He ran a stop sign and hit a lady. We were insured, so we were covered by mini tort. And she was so mad at him. He was about 22, maybe. And she just berated him at the site of the accident. Police officer told him to go stand somewhere else because she was so upset. We did pay her the mini tort amount. So tempers can rage. But the bottom
and
line is this cost her $2,211.51 to repair her car. How much can you pay each month?
well, I'm not 100% sure just because I do have wages being garnished already out of my check due to something else. And also, I would like, if possible, the court fees to be covered by her or somebody else because I did try to come to an agreement with her. I did reach out to her. I did text her my number, my real number. I did try to communicate with her. I just needed a piece of paper stating that this is what I owed her. That's really all I needed.
All
I
right,
didn't
that's
need
what this is.
so.
So I'm gonna give her court costs, but Judge McManus used to make everything payable within 24 months. Judge McManus was judge here when you were about 3 years old. I took over 24 years ago, and he was the judge for 36 years before I got here. But he started the court and he tried to divide everything essentially within at least 24 months. So I would expect that you would pay at least $100 per month regarding this. Are you able to do that?
That's fine. I can do that. Can I start that in January though? Because I
Yes,
am getting
January
my,
15th
that would be great. I appreciate it.
and the 15th of each month thereafter. Now, you
Sounds
can
good.
pay more if you want to just get this over with. You get a tax refund, or you sell a car, or you win the lottery or something. But as long as you pay $100 per month, she can't pursue a garnishment.
Okay. That's fair.
Ms. Brandes, are you still at Pondview Lane?
I am.
Is that the new subdivision off Ash Road?
It is near it, yes.
All right, and Miss Friesen, you're still at Laura Court, Apartment D?
Yep.
All right. I'll send you each a copy of this judgment. You send $100 per month directly to her. I'd suggest you send it by certified check or money order. Again, if you want to get it done sooner, just pay it off with a tax refund or something. But as long as you pay that amount, she can't pursue any other collections. Ms. Brandes, do you have any questions?
If she doesn't send by certified check or money order and decides to send a personal check, let's say, and I don't feel comfortable cashing that, what are my options?
Well, if she sends you a personal check and you cash it, great. If it doesn't clear, then we've got other issues, including NSF check. But I would, before I reject it, I would at least attempt to cash it.
Okay.
All right, ladies, I hope everybody goes on from here. You probably won't see each other. You live in Three Rivers, she lives in Sturgis. I'm not sure what kind of cheer practice was going on in Centerville, but
Our children
It's
go to
not
school
like
together.
cross
So.
paths much anymore. All right, you're both free to go. Thank you.
Thank you, Your Honor. Merry Christmas.
Thank you.
Thank you. This is Rogalski versus Caleb Evink. File number is 252447SC. Oops. I'm on a live stream it out on the record. Mr. Rogalski is not here because they were unable to serve him with a lawsuit. Although he shouldn't be that hard to find because he's on probation to my probation department. His probation agent is Daniel Frazine. I'm familiar with this circumstance, Ms. Rogalski, because I sentenced Mr. Evik on a drinking driving charge. The prosecutor reduced this to impaired, and I did a sentence as a result of this accident. As I'm starting to read it, I thought, boy, this really sounds familiar. Then I realized it was that case. So we can't proceed today because he has not been served. I can't do a default judgment unless he actually knew he had a hearing. Defendant is on probation.
I was told by a Kimberly, sorry, I was informed by a Kimberly Steele that it may need to be rescheduled since he wasn't served, which that's of course what I have to be happen and move forward from there.
We will reserve it. But defendant is on probation. So we know where he is. I'm not sure the process server knows where he is, but matter will be reset after 30 days to obtain service.
Just like to get home.
Excuse me. This points out what happens when you're in an accident and you don't have insurance. You're not covered by the no-fault statute. He was convicted of impaired driving. He's on probation, so he should be fairly easy to find. So, Ms. Rogalski, you're good to go. We will reset it once we get service on him.
Thank you for your time.
All right, that's why I'm here. Thank you. Mr. and Mrs. McLean, why don't you come up and have a seat right here? All right, we're kind of in the same boat. This is Raymond McLean and Kim McLean versus Mike Shashulski. File number is 252304. It was filed as Mike Shashulski and Greenbuilt.
Now the courtroom shifts from deciding fault to finding a practical solution. The defendant says she never refused to pay, she just wanted proof of the repair costs before handing over thousands of dollars. The judge appears to accept that explanation, but he's also making it clear that once the damages are verified, payment isn't optional. The only question left is how that repayment will happen.
Roofing. Plaintiffs live on Ottawa Road outside of Mendon and are very dissatisfied with the roofing job done by this company and have filed a lawsuit for the statutory maximum of small claims $7,000. Same thing. Mr. Shashalski and Greenbelt Roofing have not been served. Greenbelt Roofing appears to be out of business, and the mail came back and they have not gotten service. We're gonna have to personally serve them. What do you do in that regard?
Yes, go ahead.
Yes, we hired a Jayco process server in Grand Rapids, and the business address that he has is the address that we serve. He is not out of business. He's just not in that building. It's a vacant building. They're very familiar with him. They've served him countless times. So
Cornucopia of times.
they're confident they can find him.
Finding him and collecting may be two different things,
Both
but
of them,
yes.
yes.
Mhm.
And so we have their paperwork saying they attempted once and they will continue to attempt. If you
right.
need that paperwork, we have it from them.
I'll ask you to give that to the clerk.
Okay.
Very good.
We had a guy a few years ago from Kent County who was sort of the same thing. He was a building contractor. He had lots of angry customers. Channel 8 actually followed him down and pointed a camera at him and did a story about it. I'm not sure what this guy's deal is, but again, we will reset no sooner than 30 days to obtain service. On defendant. Now, this is a little tricky because you're suing him personally and you're suing the company. The company is a limited liability corporation. So there may be a question of whether he's liable or the company's liable or they're both liable. But generally you have a limited liability corporation, so you don't get personally sued. So we'll see where this goes. The company is still in business.
Yes.
Well, I'm sorry you had to get dressed up and come all the way over here for this, but we won't be able to proceed till we find him. That'll be no sooner than 30 days and we'll reschedule this. If you stop out at the clerk's office and you give them that other documentation you've got, maybe that'll be helpful.
Yes.
All right, you guys are good to go.
Thank you.
Thank you.
We're plugging away with the people that did not get served. David Nieves. We're in the same boat, Mr. Nieves. This is file number 242198SC. This is a claim where Mr. Nieves has a judgment against the defendant and at this point is trying to do a discovery subpoena. There was a consent judgment of $5,446.25. The defendant agreed to pay $300 monthly installments, did not pay. He was working at Forest River. He filed a motion to set aside the installment payments. And I indicated you could pursue a garnishment. You did this subpoena to Kapir. You had also tried to serve him in Elkhart County, is that correct?
Yes.
Did you have any luck in Elkhart County?
I did not. I mean, I knew where he worked at before and that's where he got served and then he switched to Forest River and I mean, It
Yeah,
doesn't say what line or what plant or anything, he just says Ford Sugar.
well, once you get that, you can garnish his wages. But he isn't here and he isn't served. And I can't default him unless he's served. So the same thing. We're having luck, not luck with service. Appreciate your diligence here. He does agree he owes the debt.
I mean, he recently got a DUI, and I would imagine he has probably
In
probation.
what jurisdiction?
Elkhart County. I mean, I'm pretty sure they would know more details, how to find him, or he's on probation or something.
Reset. Not more than 30 days, not less than 30 days. To attempt to obtain service. You have a judgment. You don't just have a claim that he owes you money, you have an actual judgment where I ordered that he did owe you money. If you can figure out where he works, you can garnish his wages. And that's what the discovery subpoena is about. He's got to show up and give you his place of employment, his social security number, and other ability to attempt to collect on this. But right now, you tried to serve him in Elkhart and in our county, and you're striking out. I'll have the bailiff take you out to the court office. Any additional information you got is helpful, but we can't do anything until we get service on it. All right, thank you again for being here. Our next matter is Z Smart versus Kate Yoder and Travis Baldwin. Mr. Baldwin signed for Miss Yoder, so we really only have service on Mr. Baldwin.
Yeah, I've cooperated with Z Smart now, and I've agreed to pay $100 a month to them. And the manager has agreed, and we're in agreement.
All right, the file number is 252502. The claim is for $1,694.09. And if we add in the court costs of $82.50, total is $1,776.59. And Mr. Yoder, you agreed to make payments of $100 per month?
Yeah, can I address the court though, sir?
Yes, certainly.
All right. So me and Larry had talked last week, I believe, or the week prior, and we had agreed that the total owing was only $450, and I had paid him $30 on that day, and he agreed that I would only owe him $420. So I don't understand where they're getting the $1,600.
Miss Keith, can you help on that?
Well, the full term that he owes is $1,694.09 on the mattress.
Larry is the manager.
Yes, and me and him were in agreement of the $450, and I paid him $30, and he told me I had $420 left.
What's Larry's last name?
I don't.
Byrne.
Larry, what is it, Susan?
Byrne, B-Y-R-N-E.
Is he available?
Yeah, I can go get him.
Thank you.
Yeah,
Give me a second.
okay.
Thank you, Judge.
Mhm. All right, you're the manager at Z Smart in Sturgis?
Yes, sir.
Well, you're lucky you got Susie. She's been doing these cases for years, but this one, we need your help. The claim is for $1,694.09. Mr. Baldwin, the defendant, says he's met with you. You've agreed to settle the matter for $450 minus $30, which would leave a total of $420. What do you know about that representation?
You know, that's correct. Him and I did speak about it. It is correct.
Appreciate that.
All right, I'm gonna change it to 420.
And I do apologize for the confusion. I did not let Susie know that. That's my fault.
All right, 420 plus 80, 250. That's court costs. Well, it's very helpful to have you here and clear it up right now. 50250 is the total.
Okay.
Payable at $100 per month. When does that start?
We can start it after the first of the year.
I'm gonna start at January 15th,
Perfect.
2026. This is to Travis Baldwin only.
Yes.
Are you still at the Pearl Road address, Coldwater?
Yeah. Yes.
All right, I'll send you a copy of that judgment. You make your payments directly to Z Smart.
Yes, I will. All right.
All right, you're good to go.
All right. Thank you, Your Honor.
Today's hearing was a reminder that small claims court is all about resolving disputes with facts, not emotions. Whether it was a parking lot accident, an unpaid debt, or a business disagreement, the judge focused on evidence, communication, and fair repayment rather than personal arguments. Sometimes the biggest courtroom victories aren't dramatic, they're simply about reaching a fair resolution that both sides can live with. If you enjoyed this courtroom breakdown, don't forget to like, comment, and subscribe for more real courtroom cases and legal insights.